Hello students, this is Professor McDonald, and this will be a narrated PowerPoint slideshow. This will cover chapters 10 and 11. Next slide. Let's start with chapter 10, Constitutional Mandates, Overview of Executive, Legislative, and Judicial Roles. This is a pretty important chapter because we're starting to get into the legal aspects of not only the war on terrorism, where you're dealing with intelligence gathering, you're dealing with counterterrorism and some of these key issues, and the law can be very, very complex relative to these issues. Actually, I have a separate course that I do on terrorism, constitutional and legal issues, but we're going to touch on it some in this chapter. Next slide. It's interesting, there does exist a paradox, so to speak, of intelligence as democracy. When we think of democracy, especially in our country and our environment, we think of openness and government accountability to the people. Our elected leaders work for us. The reason we had a revolution is because we were treated as second-class citizens answering to a monarchy, the king. And ultimately, the level of treatment, negative treatment that the colonies received, ultimately led to a revolution, which of course then resulted in the founding of our nation. And where the paradox comes into play here is intelligence by its very nature is secret. And secrecy is really the antithesis. It butts up against democracy because in our democracy in particular, the people are very suspicious of government actions that are not open and subject to clarity by the public. But as you know, as we know, having gone through this course, when you're dealing with intelligence, the ability to keep things secret is critical, because we know the old saying, loose lips sink ships. But it's something important to remember, that this openness, it bashes heads against the requirement of intelligence to be secret. And you know, you have to always remember that our actions as intelligence agencies are not governed strictly by the administrative rules of that intelligence agency. The paramount document that they must look to, of course, is the U.S. Constitution and our laws. So just remember that it's a very difficult balance when you're trying to balance the rights of our citizenry, but also we have a nation to defend. We have national security interests that have to be addressed, and there is a certain level of secrecy that is required when you're dealing with this type of subject matter. As we move forward, we'll talk about the First Amendment. Of course, that's our freedom of speech amendment, right to free speech. And another major amendment that is impacted is the Fourth Amendment, which protects us from illegal search and seizure. So we will address those later. And of course, there's nothing more important, as you see in this slide, the Bill of Rights, which are the first amendments to the Constitution that lay out these rights that are so critical, especially from a legal perspective, if you work in this field. Next slide. Our Constitution, which is it's our foundation. When you think of a house, think of a foundation. You have to have a foundation before you can build on it. And the foundation of our democracy, of our republic, is our Constitution. And our founders were very wise in the way they set this up, because they realized that they had just overthrew a government where too much power was focused in the king's hands, or let's say the executive level. And so they wanted to make sure that this new young nation would be founded on the principles of democracy, and in particular separation of powers. And so we see our three major separate powers, and this is stuff you've all heard. You heard it in high school, and I'm sure if you've taken any history and political science classes in this, you've heard it before, and you've heard it from me if you've been in my criminal law or criminal procedure class. Of course, the executive branch, that's the president, all of his cabinet level officials, The government, as you become most familiar with, if you work in federal law enforcement, you're part of the executive branch. This could include the FBI. If you're an intelligence analyst with the CIA, you come under the executive branch. And of course, when you think of the executive branch, their principle, not only to govern, that the president has that responsibility, and also to protect our national security, but also to the within the executive branch, the authority to enforce the laws of the nation emerge. Of course, the legislative branch, and let me back up for a second. Also, under the president, with the executive branch, he has Article 2 of the Constitution. He has broad powers. He can take military action as a defensive measure. We see that all the time. He is the commander-in-chief of our armed forces. We have the legislative branch. They control and that's Congress. That's your House of Representatives and your Senate, U.S. Senators. They control the budget, the money. They have the authority to declare war. And of course, our judicial branch, their job is to look at the legality issues relative to the check and balances of government and interpret the laws. And they do this through their decisions. Next slide. Let's talk now about the 1947 National Security Act, which followed shortly after the end of World War II. Probably its most noteworthy achievement with this law, the passage of this act, is the creation of the Central Intelligence Agency, or the CIA. And there, this was a big deal. This was up to that time the largest restructuring of government in the history of our nation. Not only did they create the CIA, and there's other things that I'm going to talk about, but you also saw the former Department of War become the Department of Defense as we now know it. And of course, the Department of Defense includes all of our military agencies, the Army, Air Force, Navy, etc. And it also created the position of Secretary of Defense, which is a cabinet-level position that reports directly to the President. Now, in that post-World War II environment, it's important to remember that our politicians and our military leaders had finally realized that we no longer, as a nation, could be an isolationist. We were too involved in world affairs to be isolationists. So therefore, we have to start thinking about our own national security as we engage the rest of the world in a more proactive manner. They also recognized the failures of the prior intelligence gathering capabilities, for example, Pearl Harbor. And also you have to look at the post-war focus. We're coming into a Cold War where the Western nations, the United States, Great Britain, were faced up now against this Soviet Union, this threat from communism. And so therefore, not only do you need intelligence in a wartime environment, which is pretty obvious, but you also, because of our new engagement as a nation internationally, our position in the world, because of the influence we had in World War II, we also needed to finally establish a full-time post-war intelligence capability here in the United States. And that's one of the reasons this act was created. And with the CIA, there's a mandate. You see the bullet points there: collect intelligence, correlate, evaluate, and disseminate intelligence. These are things that we saw in the intelligence cycle chapter. Provide direction and coordination of intelligence outside the U.S. That's important to remember. The CIA does not have the authority to collect intelligence within the United States. They have an external focus and perform other functions as needed. The Act also created the National Security Council, which is comprised of the President, the Vice President, the Secretary of State, Secretary of Defense, and others as selected by the President. And I've already mentioned the Department of Defense. So this was a major piece of legislation which went a long ways in codifying and establishing a full-time, not just a wartime, but a full-time intelligence capability here in the United States. Next slide. Some people say, well, what about intelligence? Is it against the law, international law? And it does not. There's nothing in international law which precludes a nation from gathering intelligence and, in particular, conducting espionage activities. Because many times, as our textbook says, intelligence may be the key that stands in the way of otherwise aggressive encounters between states. So as long as states can collect information that's relevant and necessary to their own security, they may delay their urge to resort to armed conflict. So that's how the international community looks at it. We can keep each other at bay by knowing the strengths and the weaknesses of of the various nation states. There's a lot of discussion about the use of drones, but before I do that, let me just talk about a few other items that are listed in this particular slide. Executive orders. These are orders that are issued by the President, and in particular, the Executive Order 11905 and 12333 prohibited political assassination. And what we're talking about is, we as a nation, these executive orders prohibited us just from saying, okay, we don't like the leader of this nation, we're going to send in a hit team to kill that person. Or we don't like the prime minister from a country, let's send in a hit team to kill him, and maybe we'll get somebody that's a little bit more amenable to our political perspective. But yet these executive orders did not fully ban the practice, but put decisions in the hands of the President. So the President, these executive orders do exist. They're called assassination bans, but there are certain avenues where the President can authorize the use of deadly force in certain situations. It does not apply in wartime situations. Also, if the President feels that an act is in self-defense, like for example against terrorists, then that is authorized under the executive orders. And that's where you would get your drone strikes. The use of drones, and I think everybody knows what a drone, unmanned vehicles that carry wartime warheads, and we've killed many terrorists in places like Pakistan, Yemen, Somalia, and other countries where the terrorist threat is, especially enemies of the United States, are located. Also in Kosovo, attacking leadership, the leadership command center and control centers, that's another example where it's authorized. In that particular case, we were part of a UN group that went in to and attacked the Serbs who were dominating Kosovo, and the ethnic Albanians, who were 90% of the population. And this UN group of countries drove the Serbs out of Kosovo, and now Kosovo is an independent state itself. Also, back, they talked about the attack against Libya for retaliation of attack. You know, we had some military personnel that were attacked by Libyan agents, and in a Berlin, Germany, in a nightclub in Berlin, Germany. And as a result, I remember President Reagan sent in some bombers, and he attacked the Libyan capital. And of course, what they say is they weren't specifically targeting individuals, but buildings or whatever. And you know, these things are all subject to interpretation, is how you look at it. But I think the main point is that these executive orders do exist, but there obviously are ways around them based on our national security, our wartime interest, etc. And these things have, and again, these things have been exercised in the recent past since these orders were issued. And as far as the U.S. is concerned, we can attack terrorists and other leaders planning attacks against U.S. interests, and that only makes sense. Next slide. Authorization for use of military force against terrorists. Okay. After 9/11, obviously, we realized we were in a war, and then we started looking back and we realized that Al-Qaeda had actually declared war against us earlier, several years before 9/11. And so the Congress issued an authorization for the use of military force against terrorists. It allowed military forces to be used against those who attacked the United States. Of course, in this case, it wasn't a nation state. It was a international terrorist network called Al-Qaeda. We also were able to use, and again, we could use force against Al-Qaeda in keeping with the Geneva Convention, and what we'll find later is, and if you take the terrorism legal course, we get into great detail of this, how the Geneva Convention and people that are designated as prisoners of war by international legal standards becomes quite a legal issue in the war on terror, because Al-Qaeda really doesn't represent a nation state, and the Geneva Convention was essentially establishes that enemy combatants are people that represent a nation state. So how do you treat terrorists? They're a little bit different, aren't they? So that, I don't want to go into too much more detail other than just to show you the legal implications that can emerge from these type of actions. And the CIA itself was also authorized by the President to target members of Al-Qaeda. CIA is an intelligence agency. It's not a law enforcement agency, but it does have a capability, a paramilitary capability that they use when they're working in places overseas. And as I've already mentioned, we've had military drone strikes in places like Pakistan, Afghanistan, Yemen, and Somalia. Next slide. Now let's take a look at the intelligence in the Constitution. Of course, again, the Fourth Amendment, it applies to, it does apply to intelligence intelligence activities. Fourth Amendment is, of course, the right to be free from illegal search and seizure in your homes and your personal effects. So if somebody's wiretapping you, are they not intercepting your conversations? Well, that becomes a Fourth Amendment issue. Our Constitution talks about the Due Process Clause, which we guarantee each person in this, every American citizen is entitled to life, liberty, and the pursuit of happiness. And so the Fourth Amendment is probably one of the most important amendments in our Constitution, and there's been many, many, many legal decisions that have been made relative to the Fourth Amendment and how it impacts the law. So intelligence activities do have a major impact on the Fourth Amendment, and we'll talk about some of those. Again, let's talk a little bit in a little detail about the Fourth Amendment. In the book, they talk about the Katz case, Katz versus the U.S., and this was a wiretapping case, a case that I'm very familiar with because I teach this case when I'm teaching the criminal procedure class. But in Katz's case, Katz was a bookie. He was a guy that did numbers, and he would get on telephones, and he would have but he'd have interstate phone calls with his clients, etc. And what the FBI did was they located the public telephone that Katz used, and so they put a bug outside that phone booth so they could monitor the conversations. Okay, they actually wiretapped the exterior of the public phone, and so when he went in there and made his illegal gambling phone calls, they developed evidence. They ultimately arrested him, and he was convicted, and he appealed it, saying that it was a violation of his rights, and the Supreme Court agreed. And essentially what the court said was, and I like the quote they used, and held that what a person preserves as private, even in an area accessible to the public, may be constitutionally protected. So for Katz, when he went into that phone booth and he shut that door behind him, he expected that conversation to be private and not monitored. Now, had the FBI gotten a search warrant based on probable cause, and they had that search warrant in place when they recorded that conversation, they would have had no problem. But they didn't have a search warrant, so therefore the search, the illegal search and interception of those phone conversations were illegal, and the conviction was overturned. So a very important decision. Just kind of explains to you how intelligence can also be impacted, because that's what you're doing. If you're engaged in intelligence activities, it could be at a law enforcement level, or it could be at an national security intelligence level. You have to take in consideration the Constitution. So what ultimately happened was, even though Kat's decision and other decisions, it was ultimately because the Supreme Court didn't really, that particular case didn't specifically address national security. Obviously, it was open for interpretation. As our book talks about, there were some violations that ultimately were determined by the courts to have the courts determined that the government had overstepped its bound. I think there was an Operation Chaos that we talked about earlier in this book, and how there was a program operated by the CIA to determine how foreign governments and political organizations influenced the Vietnam anti-war movement. So in addition to spying on foreign citizens, they collected information about U.S. citizens, and that's where things really crossed the line. The CIA has no right to collect any information on U.S. citizens without proper justification, and in particular search warrants or court orders. And so what you have was presidents that were usurping that authority. President Nixon got caught up in it after the Watergate scandal, and he had authorized the wiretapping of civil rights targets, which obviously is wiretapping American citizens without warrants, etc. So this is where the law started. We're leading up to what would be ultimately the Foreign Intelligence Surveillance Act. So we know that there's been decisions. Katz was not a national security case, but it was a law enforcement case. But still, you had a precedent there that was set. Hey, if you're going to wiretap Americans, you need a search warrant. Of course, didn't seem to have as much problem if you were wiretapping foreign citizens that were suspected to be engaged in espionage, for example. The court had made it clear in the United States versus Trong Dinh Hung on page 213 that foreign citizens do not receive the same amount of protection as U.S. citizens when it comes to Fourth Amendment rights. And again, I've already mentioned that Richard Nixon was involved in domestic electronic surveillance in the name of national security and civil rights activists, student groups, and war protest groups. So these abuses of power by the executive branch ultimately led to a very important bill called the Foreign Intelligence Surveillance Act, which was passed in 1978. And it was really a reaction to the overextension of authority and the wiretapping of and intercepting of telephone calls or even conversations of American citizens without proper justification or legal paperwork such as court orders or search warrants. Next slide. So before, this slide deals with the Foreign Intelligence Surveillance Court, which was created by the Foreign Intelligence Surveillance Act in 1978. So let's do another quick rundown. In 1928, in Olmstead versus the U.S., the Supreme Court said the government can wiretap without a warrant. So all presidents did it, even though it seems to be a direct violation of the 4th and the 14th Amendments. And then along comes Katz in 1967, and the courts say we do need a warrant, but that it does not apply to international intelligence and national security issues. So that question still was in the open. It hadn't been answered by the courts. And then in the 1960s, you have this Operation Chaos where the CIA is illegally targeting, CIA is targeting foreigners and their influence on anti-war movement, but they're also spying on U.S. citizens, which is obviously beyond their legal mandate. And then you have the next evolution. You have the Nixon White House is conducting domestic electronic surveillance on civil rights leaders. But still, and that's without warrants, but still, up to this point, the courts had said that surveillance of foreigners, if it related to national security issues, was okay, no warrant needed. And then in 1978, we have the Foreign Intelligence Surveillance Act passed. President Carter signs it, and the goal of this act is to protect U.S. citizens. And before a court order can be issued, the government has to show a connection to a foreign power or terrorist. That's really what it's going to boil down to, is what we deal with today. And before an electronic surveillance is authorized. Then we have this Foreign Intelligence Surveillance Court. So if you're an FBI agent and you're working a foreign power investigation or a counter espionage investigation, or you're working a terrorist investigation, if you need a warrant or a court order, you need to go to the Foreign Intelligence Surveillance Court. It's a secret court, closed door. There's 11 federal district court judges that sit on it. They're appointed by the Chief Justice of the Supreme Court. They have term limits. There's also a Foreign Intelligence Surveillance Court of Review that can review any appeals relative to actions taken by the court. Interesting to note that prior to 9/11, the Foreign Intelligence Surveillance Court Review Court had never heard one case. But ultimately, it's the U.S. Supreme Court that makes decisions. This is a secret court, and again, the targets must pose some sort of a national security threat. So if you're working a robbery case or a burglary case, you're never going to appear before the Foreign Intelligence Surveillance Court. And just remember, the significant purpose of the intelligence community relative to national security is to collect foreign intelligence, the threats that we receive from foreign powers trying to steal our secrets. And then if you can establish that, then you would apply for in a court order. If you've got enough information and evidence to show the court, they'll issue a court order, and then you can go ahead and conduct your electronic and your physical searches. Next slide. The Patriot Act actually amended FISA and because of the challenges that the government was facing, it gave some additional powers to law enforcement and their ability to combat, in particular, terrorism cases. Another thing I wanted to quickly mention is you have to be careful if you're working these type of cases, because if you look at the Aldrich Ames case in 1993, he was the CIA spy, double agent, who was ultimately caught and sent to prison. The FBI searched his house without a warrant, so you surely wouldn't want that evidence to be destroyed, would you? Where you couldn't use it against a guy like him, and if he gets let go, then that would just be a terrible travesty. And again, the USA Patriot Act was passed after 9/11. Some of the features that it allowed would be roving wiretaps that target persons, not places. In other words, you can get a wiretap for an individual who's the target. You don't have to get it for his phone in his house, and then if he jumps in his car and he's on another phone, you have to get a separate warrant for that phone. And then also, he might have a house in New York and a house in California. Do I have to get a separate warrant to monitor his conversations in New York and then go to the court in California and get another separate warrant? No. The Patriot Act amended FISA, which you would have had to done that in the past, to allow multi-point or roving wiretaps to target persons, not places. So I can get a warrant on John Q, the terrorist, And whether he goes to New York, Georgia, or wherever, I can, that one warrant will cover me wherever he goes. Section 215, strengthen our ability to procure medical, library, business, and travel records. It allows for the information obtained in a FISA investigation to be shared with any government investigative agency or attorney. That breaks down those walls of communication. And they actually did, with the Intelligence Reform and Terrorism Prevention Act of 2004, they amended FISA itself, or an agent of a foreign power, to include non-U.S. persons acting as lone wolf terrorists. You think of Richard Reed, the shoe bomber. Next slide. There's also some other legal concerns that come into play. Just remember, just to back up, when it comes to databases where intelligence is maintained, law enforcement needs reasonable suspicion to include a person's information in an intelligence database. You just can't dump people's information in there. First Amendment rights, you can't investigate people based on their religion or political viewpoints. We also have an Espionage Act, and this is where this WikiLeaks with PSC Bradley Manning, and basically it's important to remember that it can be a violation of law if individuals, whether they're military or civilians, reveal classified information to the public. We have to have these type of laws in place. And the, hold on one second, let me get my notes here for a second. Again, the 28 Code, CFR, Code of Federal Regulations 23, just prohibits agencies from retaining intelligence on innocent people. You always have to have that reasonable suspicion that people are engaged in some sort of activity or criminal behavior. National security letters, they're like administrative subpoenas or secret demand letters that allow the government to demand customer information from communication providers like Sprint, AT&T, whatever, financial institution like banks and credit unions, and the key element to a national security letter, if you're looking at a target, perhaps a foreign individual or a terrorist, is that when a company or an entity like, let's say, Sprint, receives a national security letter, they need to turn over whatever information that's requested to the government, but they also have to keep the letter itself and the information revealed secret. In other words, they can't tell the target that they've obtained this information. And that becomes a little different when you're dealing with search warrants. When you execute a search warrant on an individual, you have to leave them a copy of the warrant plus a copy of any information you've taken. So this secrecy aspect of it, obviously if we're looking at a foreign spy and we get some of his records, his bank records or communication records, we don't want these companies to notify him, because then he'll hightail it out of the country before we can actually build a case on him. We also have, next slide. There's some key Supreme Court cases. The Holder versus Humanitarian Law case, that relatively dealt with individuals providing financial support or aiding and abetting, whatever. Let me back up. Providing material support, which could be monies or whatever, to organizations. And for example, let's say if I'm an organization and I give my money to the ABC charity, and this charity has lawful things that it does, but also it funnels some of its money to unlawful activities like terrorist activities or terrorist organizations, well, how can you tell what part of that money? The term they use is money is fungible, F-U-N-G-I-B-L-E, it's fungible. If I donate to that charity, what's to say the money I'm not giving them is going towards terrorism? You can't just say because some of what the charity does is bad, but most of it's good, that means that that you can't be held accountable for contributing to that organization. So that's what that case was about. And the Supreme Court ruled that any material support to a terrorist organization, regardless of the supporter's intentions, violates the Patriot Act. So that was a good decision. Hamdi versus Rumsfeld basically said the United States could detain for the duration of the conflict individuals captured incident to war. And this is dealing with the war on terror. But the course also stated that if we picked up a U.S. citizen, they had the right to challenge their classification as an enemy combatant before a neutral decision maker, which would be a judge. In Boumediene versus Bush, the Supreme Court found that even non-U.S. citizens who are held as detainees in Guantanamo Bay have a right to seek a writ of habeas corpus. And of course, habeas corpus allows a prisoner to demonstrate that they're being held in violation of the law or due to an erroneous application of the law. You challenge your imprisonment. Of course, Guantanamo Bay is the place where a lot of these really hardcore terrorists were maintained. Another thing you want to look at is make sure you revisit the Classified Information Procedures Act. It's designed to guard against gray mail or a defendant's threat to release classified information to the public. This is one of the problems with prosecuting these type of cases, is many times the government might, to get a good prosecution, they might have to use classified information to obtain that prosecution. And that becomes very, very shaky because the government might not want their techniques, their classified techniques, or their classified targets to be released in open court. So that becomes a real challenge in these type of cases. This is Professor McDonald. Now for Chapter 11, which is writing and briefing for the intelligence community, they only have one slide. I'm just going to kind of go through some general discussion. It's very easy to understand the readings in this particular chapter, but let's talk about it a little bit. It's important to remember that if you work as an intelligence analyst, there are certain functions that you perform on a daily basis. Obviously, analyzing raw information, developing intelligence products, you draft assessments, and you disseminate those assessments to policymakers or your requester through either written products or a combination with oral briefings. So individuals who work in the intelligence field, not only do they need good writing skills, they also need good briefing skills, oral skills. One of the first things they, and another thing let me just mention about intelligence products also, sometimes an individual analyst will be asked to prepare a product, but a lot of times the work they do is collaborative, just like when you collaborate on a request, you're working together with a team on trying to develop information and intelligence on a particular request that has been provided to you, and you're trying to produce a report that addresses that request. Again, it's important to remember that you do work with analysts, other analysts also on the written documents, and also possibly you could have a team briefing. So again, these communication skills are essential. Intelligence papers themselves can be strategic or tactical. Strategic, again, is looking at the big pictures. Tactical pieces are often more immediate, composed about information that maybe the military or law enforcement or intelligence collectors wish to carry out in operations. It's much more time sensitive in its focus. One of the strategic products is the National Intelligence Estimate. They take on international issues, and they look how those issues affect U.S. national security, and they assess long-term the impact of these issues on the United States. And these these could be forecasts that go out several months. They could be years or whatever. And again, compared to tactical, which might be something that's much more immediate. Maybe the Joint Terrorism Task Force needs an immediate report so they can make a decision on whether it's time for them to move on a particular group through an execution of multiple search warrants or get a wiretap, that sort of thing. So that'd be more of a tactical nature. You have daily intelligence, which involves issues immediately affecting the United States within, say, the past 24 hours. The President of the United States, he gets a daily briefing, and that briefing can be it can be oral or it can be a written report. It's assembled by a small team of senior level analysts, and it includes information taken from all the 17 intelligence agencies. It's you know, in the book they describe it as like the President's ultimate morning newspaper. Well, that's what he's going to get briefed on first thing in the morning, as exactly what is the state of the world today. And as we look at the threats and the things of interest to him, I mean, they don't make up what they think he should know. He's already told them what he's interested in, and then they'll include other additional information that also may be an interest to him. He's the ultimate requester when it comes to intelligence products. Some of the presidents, I know they talk in the book that George Bush preferred to have an oral briefing, whereas Bill Clinton preferred the latter. He just wanted the written report, and he would digest it himself. And of course, there's also give and take, and based on the briefing, maybe the president wants some additional work done or some additional information or analysis done on a particular topic. That information would be fed back to the analytical team, and then hopefully in the next couple of days it would be addressed again. Answering the questions that arose during that briefing on that particular date. So again, that's a big part of his job, or her job, is knowing exactly what's going on in the world, and the intelligence community is there to provide that. Other type of warning intelligence, that looks at the potential threats against U.S. interests and prioritizes the issues to which the intelligence community is concerned. In other words, whether there's an immediate crisis or threat, and what are they looking for? Any developments which could indicate that a hostile state or a group is preparing some new action which can endanger U.S. security interests. It renders a judgment. It could be there is not a threat. Again, if we go back to our milestones and our indicators, if you remember that exercise, things that are observable actions that would indicate that something is going down. Intelligence contains estimative language, which are analytical forecasts, which estimates whether or not the predictions are going to be true or not. They're more or less, again, the analyst is requested to make a judgment regarding issues that have been assigned to that analytical team by the requesters at whatever level. One of the things they talk about in the textbook is bottom line up front. I know if you write a paper for a professor, normally you'll provide your theme or your thesis early in the paper, and then you wrap it up with your grand conclusion based on the research that you performed. Well, in the analytical world, that is reversed. Policymakers are busy people, and they don't have time to sit there and read an 80-page report. They want the bottom line up front. That's the term they use. They want to know exactly what are you predicting, what are you forecasting. Give me what I need to know on the front end of this report. And then, of course, the rest of the report would be the supporting information that supports your forecast as an analyst. So they want the bottom line up front. Give it to me. You've done this work on this request. This is what you found out. Tell me that right on the front end. It should be very declarative sentence. They give a good example in the textbook. In the last 6 months, Utopia's currency is destabilized, the military is revolted against the government, its executive power, and the country will very likely become a failed state within the next 3 months. Well, that's bottom line up front. Now I know exactly, if I read this whole report, this is what it's going to tell me. So for busy people, that's important, and it's sometimes it's not an easy way to write. I know in law enforcement we used to have executive summaries as well, and that would be kind of a bottom line up front report. In other words, you might have an investigation, but on that front top page, going to the U.S. attorney perhaps who's prosecuting the case, you would tell him, you would capsulize exactly what this intelligence report or what this investigative report is going to show you, what the evidence shows. So again, policymakers, they like that. They like that bottom line up front reporting where they get, you give it to them right on the front end what your work has produced. Analysts also, they make judgments. I mean, it's that simple. And there are different confidence levels that are expressed in the analytical process, and normally they're expressed, there's different ways to express it, but in the textbook they talk about high, moderate, or low level of confidence in their conclusions. So if they feel very strong that the indicators are there that something is going to happen based on their analysis of the information that's been developed and the intelligence that has been developed, then they might have high confidence that this is what's going to happen. This is what we're forecasting. On the other hand, if the indicators are not there or they're very weak, their bottom line up front report may express a confidence level that is very low. And it's important to understand these different levels. And of course, once you work in the field, the requesters, the policymakers, the users of your product, they'll get used to your writing style, and you'll develop your reputation based on the work that you do, the accuracy of the work, and of course the confidence they'll have in your ability to actually assign the right confidence level to your work. They also use estimative language, which is to convey the likelihood that something will happen. Remember, finally, good intelligence writing must include analysis. In other words, you're taking something, it's like we talked about creative thinking. You're taking something and making more of it. You're not just repeating a situation. You cull from the many sources of information that's available to you, the most relevant information, and from that information you draw conclusions and you provide a report, and then you provide the confidence level in your interpretation of the information that's available as to what you think is going to happen. The textbook also talks, I'm not going to talk about proper English and proper grammar. That should be self-explanatory in this particular chapter. But again, I think it's important to remember that writing and briefing for the intelligence community demands a certain form of communication from analysts. If you work in intelligence, you're not going to sit in a room and just hide and not have to brief people. You're going to have those writing and communication skills. And I can take this. I've seen criminal investigators that could do a great job investigating a case, but they write a lousy report. And at the end of the day, if you're reading that report, it also makes it look like it's a lousy investigation. Even though they might have done a very good job, they just did a poor job of explaining exactly where the evidence was, the investigative work that they did, what the evidence shows, etc. So good oral and writing skills are essential in this field. And always remember, bottom line up front when you're dealing with intelligence. And that'll end this particular narrative slideshow for chapters 10 and 11.